Good morning friends, Sat Sri Akal, Adab. Now continuing my videos, this is my 162nd video and this is again covering a cantonment called Kasauli, and this is related to a property which was originally called Handley Cross Estate, survey number 114, approximately 0.97 or 1 acre only. This property originally was called Dovedell Estate and the survey number or the property number at that time was 21, and this is, I am talking of a sale deed in 18th July 1919 when this bungalow was actually sold for about 14,000 rupees and it exchanged hands. So why this survey number 21, or whether bungalow number was given or was there existing in the sale deed in 1919, and why the name has changed from Dovedell Estate to Handley Cross Estate. So these are many questions which we can answer back or we can pick up questions on. The truth is that in 1949 the MEO Delhi Circle then issued a resumption notice on 30th April 1949. And the offer made was 6,000 rupees of the authorized structure. Now whether this was justified or not is a matter to be seen. This action of the authorities was challenged by the petitioner then, and the courts at that time were at Fatehgarh Sahib at Bassi in Punjab, joint district judge. The suit was contested, but the trial court, by its judgment dated 30th November 1953, came up with the conclusion that the entire fiasco of issuing a resumption notice was illegal. And it is very important that the plaintiff at that time was claiming in 1953 50,000 rupees as compensation for this bungalow. So the conclusion was very simple, that the notice was null and void. The decision basically revolved around the quantum of compensation when it was even challenged in High Court of Punjab. A petition was filed, RFA number 12 of 1954, Punjab. Again, the High Court came down to a conclusion that since the parties were under litigation and the resumption was not proper, at this stage we will not get into the technicalities of ownership and all. Since the quantum of compensation is wrong of Handley Cross Estate, the owner will be entitled to receive the rent of some approximately 1881 and 40 paisa per annum, and this resumption is quashed. Now 1958 everything settles. Okay, 49 was the original resumption notice given. Now this bungalow again on 6th November 1969 is issued a resumption notice, and this time late Shri Jagdhar Mul would be Sood. It was mentioned therein that this property 0.96 Handley Cross Estate belongs to government under old grant GGO and so should be handed over within 30 days. But here the High Court made an observation, as the dispute was pending and the compensation can only be decided later. So this entire petition which was filed against this resumption notice of 1969 under Article 226 and 227 by Shri Durga Das Sood, and the claim made on the property was 75,000 plus a rental of per annum of 4,422. Now what was the pleading which Mr. Durga Das Sood or his advocates made? We'll go one by one. This is very important because this case is very important. Please listen. So initial pleading came down under Article 31(1) of the Constitution, which it neither fixes the amount of compensation, and what is the principles of resumption, whether public purpose, and what is the acquisition value, and so many things, and Central Research Institute, whether it needs it. So these all facts were basically admitted in 1958. So what really transpired in the next 11 years? They issued a resumption notice in 49, holded it back till 58, final order, come back again in 69, again issue a notice, again that GGO. So these all things make a lot of questions. So these submissions work when they were coming up. So the advocate of Durga Sood pleaded on the Constitution, Article 372, 13(3) AB, and Article 366, subpara 10, and Article 372. So we'll hit into Article 31, 1, 2 of the Constitution also, but talking of Article 13 of the Constitution, what does that say? All laws in force in the territory of India immediately before the commencement of the Constitution, insofar as they are inconsistent with the provisions of this part, shall to the extent of such inconsistency be void. Article 13(3)(a), law includes any ordinance, order, bylaw, rules, regulation, notification, custom, and so on and so forth. Article 13(3)(b) says law in force includes law passed by legislatures or whatever. What does Article 36(10) says? Existing law means any law, ordinance, orders by law, legislations, and so on. So Article 372 speaks of the continuation in force of existing laws and their adaptation. Hence, it is obvious from reading these articles that the law includes any ordinance, order, bylaw, rules, regulation, custom, or uses. So who's the competent authority, and how, and was not repealed before the commencement of the Constitution? So these were saved back in Article 372. So let's put it this way. What is the petitioner trying to say? So the first pleading what the petitioner pleads is very simple. He pleads res judicata. Why does he do that? He says when a case was already decided by the Fatehgarh sub-judge Basi way back in 1949, will not this resumption notice again operate as a res judicata? It is interesting. 11 years later, the department comes back, and what does the court say on this? One of the points urged by the respondent in opposing this petition is that it is barred by res judicata. But it may be stated here that in the previous case, the decision of which is alleged to operate as res judicata was not decided on merits. Rather, the same was decided merely on the ground that the notice as given was invalid, and in the High Court also the case was not decided on merits. Therefore, the previous case being not decided on merits, the same does not operate as res judicata. Friends, I've been hitting my head. Please dig into any of your court cases. Anything related to house tax, related to admission deeds, related to construction, any notice, if there is a finding after full process decided on merits, you will get stuck up in res judicata. Now, by 1884, there were some difficulties. Now, what the pleadings in the present case is being done of the 1969 resumption in obtaining houses near the barracks occupied by the regimental officers. So within these limits of the cantonments, when in 1884 this brief was being prepared, the government appointed a committee consisting of secretaries and legislatives under the military and home departments to consider this problem, and finally a bill was produced, number 17 of 1888. The bill was introduced in the Council of Governor General of India 12th October 1888 and its chapter 5 was headed Immovable Properties in Cantonments. But subsequently, due to some opposition, this chapter was omitted, and in 1898 government introduced the House Accommodation Bill, which was passed in 1902. In the course of discussion, the Honorable Justice Pugh said, "I think the bill will put the house owners in cantonment in a better position than they are in at present. It will take away a great deal of that uncertainty which at present behests them. They will have a bill showing clearly the position which they stand, instead of being liable to have military regulations made with respect to them at intervals perfectly uncertain, and military regulations, the scope and result of which also they cannot foresee." Please understand. I get this smile on my face when I read this. I remember there was a very senior lawyer in Ambala. He was arguing me, "Mr. Das, can you explain me way back, I think in 2015 or 14, what is House Accommodation Act?" So one of them, who is already a lessee in the cantonment, said, "House accommodation will ruin our life. House accommodation actually says that we are not owners of this property." And if people read these bills and everything, what does it say? Now, I will further read. It was observed by His Excellency the Viceroy as the President of the Council. It was subject that raised many thorny and difficult questions respecting the rights or the assumed rights of individuals. And we all know how readily, when a question of property is concerned, the bristles of the Englishman, and I think I may say the Indian too, who has perhaps learnt a good deal from him, are apt to raise. In the light of the earlier histories of cantonments, House Accommodation Act was enacted, which superseded all old rules, regulation and orders. Now we'll read the preamble of the House Accommodation Act. Whereas various conditions, rules, regulations and orders have from time to time been laid down by or by the authority of the government in regard to the grant of land and occupation of land and houses in cantonments, with the object of securing, amongst other things, that houses built on such land should be made available when required for the purpose of accommodation of military officers. And whereas, notwithstanding the conditions, rules and regulations and orders, difficulties have frequently been experienced in obtaining house accommodation cantonments for military officers, and it is expedient to make better provisions for that purpose. It is hereby enacted as follows. This Act remained in force till it was repealed by the Cantonment House Accommodation Act 1923. The various rules and orders to which the collective name of Army Regulations, India, was subsequently given were all collated and set out in appendix of the Cantonment House Accommodation Act Bill, which was introduced in the Council of Governor General in India for the purpose of making laws and regulations on 4th November 1898. The appendix is found in the Gazette of India of 5th November 1898 at pages 366. These orders, this original House Accommodation Act is there in place, and the present government, whom we all enlightened for various reasons, is actually repealing the House Accommodation Act also. These orders, which were issued from time to time between the years 1789 and 1887, were all set out here and are described in various ways. For example, journal orders as tracts, proceedings of the Governor General in Council, journal orders by the Commander-in-Chief, resolutions of military boards. They cannot, in our opinion, be treated as rules having the force of law. They appear rather to be departmental rules issued with a view to the regulation of administrative business in the Army Department. The particular rules which have to consider in this case, the rules regulating the occupation of land, the disposal of premises and buildings, were first promulgated in the Governor General Order 179 of 1836. And these rules were republished from time to time with amendments and variations till they were assumed their present shape in Army regulations. In 1887, section 17 of the Gazette, page 3945, 5th November 1890, very clearly speaks of cantonment. The document of grant which was pleaded by Durga Sood's advocate in this case has not been produced in the court, and therefore the court could not know as to what terms the grant and when the grant was made. However, in so far as the regulations concerned, it was held that it was not in a force of law. My attention may also be drawn to a judgment of AIR 1939-56 of Federal Courts. The relevant portion reads as follows. It says again, speaking the applicability of GGO or any executive order within a cantonment. The result therefore is that the action of the respondents under non-existing law is invalid and illegal, and the same is struck down. On that ground, and the petitioner therefore succeed, the respondents are directed to hand over the possession of Handley Cross Estate to Lala Durga Das Sood. Guys, 1958, 1969, a man just 90 kilometers away from Ambala Cantonment won the case. Now, Kasauli people will come up and say, has the possession gone back? Has the government done anything after that? Yes, the government filed an LPA number 19 of 1979, and then they finally moved an application when application number 544 of 1980. What really happened in that? The owner of the bungalow owner somehow was on a little financial strain, decided to go in for arbitration, and the same order brought down the entire judgment of Durga Sood. What are we doing? We need to know all this. Anyone from Kasauli, please dig into these records. Last but not the least, we are old grants, not converted into new grants. Thank you. Good day.